The clerk will call the court to order.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Good morning. The COVID-19 pandemic has required many adjustments of the justice system. Social distancing and group size restrictions, as well as potential hardships on counsel of travel to Austin, do not allow us to hold argument in the courtroom. Rather than submit cases without argument, we've decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches which will require patience. Otherwise, we will proceed in the same manner as we would in person. The arguments are being live streamed this morning, and a recording will be available later in the day. We're ready to hear argument in 18-1134, W&T Offshore Inc. versus Fredieu from Harris County and the 14th Court of Appeals District.
May it please the court, Mr. Wright will present argument for the petitioner. Petitioner has reserved 8 minutes for rebuttal.
Chief Justice Hecht, and may it please the court. It's truly an honor to be the first to argue by this means, and I think I can speak for the entire bar in expressing our gratitude and pride in this court for its determination to continue on in these difficult times. In the time I have allotted today, I'd like to cover 2 points. One is, what does it mean for this question of borrowed employee to be a question of law? And number 2, how should this court look at the Ruiz factors, given that there's not really a dispute about the underlying facts, but only about how the law should be applied to those facts. We've also brought a point about the award of future lost earning capacity. Unless the court has questions on that, we'll rely on our briefs. First of all, to talk about the barred employee doctrine. This, of course, case involves an offshore platform that is in federal waters, so the Outer Continental Shelf Act applies, and the Longshoremen Harbor Worker Compensation Act gives an exclusive remedy. And the case law in the federal cases has for a long time recognized the idea of a borrowed servant also being covered by that exclusive remedy. The federal cases say clearly that this is an issue of law. The cases say that if there is a fact dispute, those particular disputes can be submitted to the jury. But in the final analysis, it's a question of law for the court to weigh those factors and define whether the person at issue here, of course, Mr. Fredieu, is a borrowed employee of W&T. And
so, Mr. Wright, if there
Yes.
are no fact disputes, you submitted the question to a jury in a way that asked them to think about each of those matters, even though you submitted a broad form question. Why do that if all of the facts were undisputed?
well,
Thank you.
Yes, thank you, Justice Guzman. We told the trial court all along that this was an issue of law, and I can give the record cites for that. But the trial court came up with this question, and we did not object to it as being in broad form. And so we're not bringing a charge error point here. If you're asking about how this should be handled in the future, perhaps just the individual questions that are at issue should be asked. But it won't make any difference in this case because you can look at the evidence and really there's only 4 or 4.5 of the factors that are in dispute because Mr. Fredieu has conceded several of them. So we can look at those factors and determine whether there really is any evidence in dispute.
It almost, Mr. Wright, it almost seemed a matter of trial strategy. Well, let's not object, do it this way, and then complain later about those specific factors. So I'm trying to understand, and I'll let you go on with your points.
Well, we told the trial court when we filed a motion for leave to file a late summary judgment, which as it turns out was 15 months before the case actually went to trial. That's in Clerk's Record 30. We said, this is an issue of law. And in the trial at 2 Reporters Record 164, the judge referenced that and asked the other side whether they agreed it was an issue of law. And they said they thought it was an issue of law. And we say the same thing at the next page. second volume of the Reporter's Record 165. So further in a discussion about the charge before the evidence closed, both the court and we said that we believed it was a question of law. That's in 4 Reporter's Record 84 to 85. So the court wanted to submit this question. The only thing that maybe we could have done differently was to say answer each factor. But as I say, you can assume the jury answered in Mr. Fredieu's favor on all those factors. Now he's conceded 4 of them, 4.5 of them. So, you know, if we look at the other factors, you can see whether there's actually any evidence to say that the original employer, and that's the question here, did the original employer, the Wood Group, control Mr. Fredieu, or did W&T? The idea that Mr. Fredieu raises that he didn't need to be controlled, that he was a skilled worker, that's been rejected by many courts. Most recently, the Mosley Court out of the 5th Circuit that came out after the Court of Appeals decided its case, said that that's not the test. The test is a comparison between the original payroll employer, which here is the Wood Group, and the so-called borrowing employer, which would be W&T. The evidence is clear. Wood Group did not give this man any instruction when he was on our platform and would not undertake to do so. The only issue that, like I say, that Mr. Fredieu raised was that morning when he was doing something different. He was supervising painters who were repairing a railing on the platform. There's some evidence that he was in charge of those other people and nobody needed to tell him what to do. Well, that's not when the accident occurred. The inquiry in the case law and in the charge is at the time of the incident in question, at the time of the injury, who had the right? Now, that's an interesting word. It's not just who was actually controlling him, who had the right to control him. So if you look at that question, and that's, we set out the factors on page 6 of our handout that are tracking the jury charge. And I've highlighted, by the way, the ones that are at issue here. Who had the right to control Fredieu and the work he was performing beyond mere suggestion of details or cooperation at the time of the injury? When he was injured, he had gone down to the control panel. He saw a regulator that looked like it was having trouble, and he called. Who did he call? He did not call the Wood Group. He could not call the Wood Group. There was no phone on that platform for him to call the Wood Group. He called by radio back to the main platform where W&T was and got explicit instructions from Mr. Mason about what to do. And his own testimony is, I got instructions and I followed those instructions with regard to repairing the regulator. So that's why I say that, you know, even though there's a lot of facts at issue, nobody has said that at the time of the injury, he was getting or had the right to get instructions from anybody other than W&T. So,
Mr. Wright,
yes.
Mr. Wright, if we were to conclude, and I'm not saying we will, but I just want your help navigating this part of the case. If we were to conclude that there were fact issues on some of the factors that needed to be submitted to the jury, what would the remedy be for that?
Well, we said as an alternative remedy, you could remand and just give the jury the ones that are at issue. But the fact is,
something that you asked for in the trial court?
No, we did not preserve that as a jury charge issue. And that's why I say you don't really need to do that, because if you think there's a fact issue on one of those factors, then you still, as the court, it's a legal matter, you need to balance the remaining factors. Many of these federal cases say,
but,
well,
but if there's a factual dispute on those factors, that would need to be submitted to the jury, right? On each individual factor is what you're saying.
well, that's really more for how this might have been done in a perfect world. But the jury.
I'm just trying to understand, though, is that consistent with broad form?
Well, this is kind of a different kind of case, because the jury is being asked some individual fact questions, but the overall question is a question of law. So I think it would be consistent with broad form for the court to say, I believe there are fact issues on 4 of these factors, and I'm going to ask the jury about those. I mean, you know, why would we put a factor in there, for example, that Mr. Fredieu concedes goes in our direction, like who had the obligation or who had the right to terminate his employment on the platform?
Well, you would,
Right.
you would if you had to do it in broad form, right? Because, I mean, are there any examples? I understand that this is the practice in federal court, perhaps, to submit those factors as granulated findings. But do we do that under Texas procedural law and under broad form? Are there other examples of types of cases where we say you submit those facts granularly and then the court makes the final decision?
Well, of course, we've got the whole Castile line of cases, but that's a little different, where there might be, you know, different sorts of causes of action in there. This is not a charge case. This is not how to.
Well, Mr. Wright, let me ask you, your client has the burden of proof to establish borrowed employee, is that right?
Yes.
Okay, and so if there are disputed fact issues and there is a particular way that you would have liked to have seen those submitted, wouldn't it have been your burden to request the issue in proper form or in the form that you indicate is needed to make a determination on some of these factors?
We said before the charge was submitted that this defense had been established as a matter of law. So we didn't need to submit anything. And that's what we're still saying. And so I'm not trying to make a charge error complaint. And that's what the other side is trying to turn this into for obvious reasons. But
Go ahead, Mr. Wright. I'll ask when you're done.
well, the jury did answer the question. And as I say, you can assume the jury answered no as to every one of those factors. And Mr. Fredieu has conceded 4.5 of them, and we can look at the others, and I think you'll be convinced that the conclusive evidence establishes that he was our borrowed servant. We were the one that had the right to control him. And as many of the cases say, control is the most important factor. He didn't call anybody else. He can't control himself. That's not a legitimate argument under the federal cases that we've cited, including Mosley, which came out last year. And so that's why I say it doesn't matter that this was submitted in broad form, and what to do the next time, I'll leave that to somebody else.
All right, Mr. Wright, did the trial court have to disregard jury? The jury said no in the end. Did the trial court disregard some of its findings to get to its disposition? And if it did, under what authority? Because I know there's a Rule 279 argument in the briefs on omitted findings.
Yes, we're not relying on the omitted findings.
Okay, so
the trial court, to the extent, if the trial court assumed that factor number 1 went in Fredieu's favor, he disregarded that based on the Rule 301 standards, that there was no evidence that would group, and that's who you have to compare. And that's what the US Supreme Court said 110 years ago in the Standard Oil case. You're comparing the two supposed employers. And sometimes people want to hire extra labor. And that's what happened here. And the Supreme Court said, and sometimes they want to hire a company to take charge of the whole operation, and they'll bring their own supervisors, and they're completely independent. So that's kind of the dichotomy. Here it's clear that Mr. Fredieu was supplied to us by the Wood Group as a laborer. He didn't come with a group. He came on his own.
The troublesome thing to me, Mr. Wright, is that is the at the time requirement. And so the minute he was injured, perhaps he was under the control of W&T, but an hour before, an hour later, the day before, the day later, that wasn't true at all. It's the idea of a borrowed employee sort of shifting back and forth minute by minute or hour by hour doesn't seem, that's not how we usually think of an employee.
Well, I understand that. I do think that at the time of the injury is important. It was in the charge and not objected to by anybody. But more to the point here, Mr. Fredieu was not under the control of Wood Group even that morning. That testimony that came from our vice president that said, you know, he knew what he was doing. Nobody needed to tell him what to do minute to minute. He was supervising those painters. That's all well and good. It doesn't mean the Wood Group was controlling him. And as the federal courts consistently say, and even the Lamelli case out of the first Court of Appeals, you can't look at it that way, because the issue is which of the two employers was giving him direction. He's not a free agent. He can't come get on our platform just because he took a boat out there on his own. He's assigned to that platform. He's assigned to W&T by Wood Group. And after that, Wood Group is out. I mean, if he wants to quit, he can go quit. But W&T assigned him to the platform, and I believe that W&T had the right to control him, all of that day and every other day he was on our platforms. Now, another one of the issues is the contract. And I believe this contract has been a little bit misread in this case, especially the part that says you'll always be an employer of your payroll employee of the payroll employer. And that's why we put, and it's about page 11 of the PDF, the number 51 at the bottom of our handout. It says, for purposes of this Article 5, an employee shall always be the employee of the entity from which he receives his paycheck. Article 5 is an indemnity agreement. It's a knock for knock type indemnity agreement where each of the two parties was going to indemnify the other for injuries to their own employees. And so that has nothing to do with whether he can be a borrowed employee. And we pointed out the insurance provisions in here where Wood Group was required to get workers' compensation insurance that had a specific endorsement that would cover barred employees. This contract contemplated that there could be barred employees. And even if it did not, the federal cases say it's not so much what the contract says, it's what that can be overridden by how people actually operated.
We consider the totality of the circumstances. There's an argument that Ingram requires us to do that. And if we do.
I'm sorry to interrupt.
That's all I said.
Okay. Ingram, of course, is about whether a partnership exists, and our statute and our common law made that an entirely a fact issue. And in fact, many of the factors in that have to do with people's intent. Intent is an archetypical fact issue. And that's why I don't believe the Court of Appeals went down the right road when they went to Ingram. I think they should have looked at the federal cases, because this is an issue of federal law that says it's a question of law. Even if you ask some questions to the jury, at the end of the day, the court resolved it. And the Court of Appeals here basically just said, well, we find there's some fact issues here. We're going to let the jury's finding on this issue of law stand. And that's
Mr. Wright, I have a question on that point before your time expires. I know you say that 4.5 of the factors the other side does not dispute or concedes the evidence falls in your favor, and that your position is the evidence conclusively establishes the other 4.5 in WT's favor as well. But just hypothetically speaking, assume that the evidence conclusively established the 4.5 disputed factors in the plaintiff's favor, so that you had the evidence conclusively establishing half of the factors in your favor and the other half in the plaintiff's favor. Could the trial court, as a matter of law, have concluded that he was your borrowed employee?
Well, you see that in several of the cases where it may not be 4.5 to 4.5, but it is still a question of law. The court has to balance the factors. Some are more important than others. And so I would say it's still possible. And the distinction here is this is a legal question. This is not the same kind of thing where every fact issue that's ever tried can somehow be decided as a matter of law because of the paucity of evidence or the overwhelming evidence conclusive evidence. This is strictly a question of law. And so at the end of the day, if you had the factors evenly divided by conclusive evidence, still the trial court and the appellate courts and this court would have to decide as a matter of law, as a legal question, is the fella a borrowed employee or not?
Any other questions? Thank you, Mr. Wright. We'll hear from the respondent.
Thank you.
May it please the court, Mr. DeBose will present argument for the respondent.
May it please the court, I'm Kevin DeBose on behalf of the respondent Wesley Fredieu. There are two legal principles that I think should both guide and simplify this court's analysis of this case. The first is that borrowed servant is an affirmative defense upon which W&T had the burden of proof and persuasion and the burden to obtain all necessary findings to support that defense. The second principle, which I think Mr. Wright has conceded, is that if there are factual disputes on any of the 9 Ruiz factors, then those disputes must be resolved by the jury before the court makes a determination as a matter of law. So if in this case, factual disputes existed on any of the Ruiz factors, it was incumbent upon W&T to obtain jury findings on those disputed factors. And it either failed to obtain findings at all, or it attempted to obtain findings in broad form fashion and lost on those issues. So the question then boils down, the only way they can escape either the failure to submit individual findings or the fact that the finding was against them and the judge disregarded as a matter of law, is to demonstrate that there was no factual issue on any of the 9 Ruiz factors. And that's what W&T has argued at every stage of this case. And based on this record, I think that's simply an untenable position.
Except that Mr. Wright says that if we assume that the 4.5 factors that he says are disputed, now you may think all of them were disputed, but he says you've conceded 4.5 of them. And he says that if we even assume that the evidence conclusively establishes the other 4.5 in your favor, that the trial court could still decide as a matter of law that Mr. Fredieu was a borrowed employee. And if the trial court could, then I presume we could too on the same record, right?
Justice Boyd, on all of the cases, and I count 6 cases that are quoted in W&T's brief, say that that factual determination must be made before the court takes a look at it as a matter of law. And I think that's the trial court or any of the appellate courts. So the only way that you even get to making that legal determination is if there are no factual disputes on any of the Ruiz factors. And let me clarify one other thing about these.
Do you concede the 4.5 factors that he says you concede?
That's where I was going next, Your Honor.
Okay, thank you.
And no is the answer to that. The first 3.5 were brought up in post-trial briefing, and the court's assignment to us was, he said, I'm weighing these Ruiz factors, and I want you to help me out with which ones weigh in each direction. And so on those factors, we said, Your Honor, there's evidence on both sides, but we concede that the weight of the evidence favors borrowed employee findings, so we're not going to contest them. And that doesn't mean that we conceded there was no fact issue. There wasn't evidence on both sides. It just means that we weren't going to argue about which way they weigh. And importantly, the trial court, in his opinion, addressed 6 factors, which he described as disputed issues of fact or contested factors. And more important than the labels he put on them, for each one of those factors, he went through evidence on both sides of that issue that he considered, meaning that in his opinion, at least 6 of them were contested fact issues, and therefore that should have been submitted to the jury.
Right, but I guess what I'm saying is, let's assume you
Now,
submitted them to the
jury. About the remedy.
Go ahead, Jeff. Justice Boyd.
I'm sorry, thank you. Just quick follow-up. I'm just saying, let's assume that they were submitted to the jury and the jury found in your favor. on even those 6. He would say 4.5 because you conceded maybe there was conflicting evidence, but you conceded the weight of the evidence established the other 4.5 in W&T's favor. But let's just assume that it was submitted to the jury on the others and the jury found in Mr. Fredieu's favor. Mr. Wright's position is even then the trial court could weigh all of that and as a matter of law say, yes, he was the borrowed employee. Do you disagree with that?
I think if they had been submitted to the jury and the jury had made findings, then under the federal scheme, that opens the door for the court to rule as a matter of law, and the court gets to balance the factors and has a fair amount of leeway in that direction. So if there had been findings and they were split and the court said, I'm considering all of the factors and I'm going to rule that he was a borrowed servant, that would have been different.
But then it becomes a harmless error analysis, because let's just assume they were submitted and there were findings in your favor. The trial court still could have found as a matter of law he was a borrowed employee.
Well, again, procedurally, the way this has to work is that they get to make those findings first, and we don't know what they would have found. We don't know how their findings would have affected the court.
Right, but I'm saying let's assume okay, we don't know, so let's just give you the benefit of the doubt and assume all the findings went in your favor.
I'm just not aware of any authority or any policy that says this falls under a harmless error rubric. This is the way the courts have been very clear. The courts have even said, there have been cases where summary judgments or directed verdicts went up, and the Fifth Circuit said there are 2 factors that we think are in dispute. And because of that, we have to send the whole thing back. Now, admittedly, and we have a chart on this, I think it's Exhibit D in our bench exhibits. There have been cases saying when there's only one disputed factor that should have been submitted to the jury, we'll overlook that if all the others overwhelmingly count in the opposite direction. But in cases where there have been 2 or more factors that should have been submitted to the jury, the federal courts have been very clear that has to go back for a jury determination. Now that leads me to Justice Busby's question about whether remand is a remedy here if there were disputed fact issues. And I think the answer to that is no, based on 2 things. The first is this court's opinion in United Scaffolding from 2.5 years ago, which didn't involve an affirmative defense. It involved a plaintiff's cause of action. But the court said that the plaintiff had the burden of proof and the burden of persuasion. And as a result, it was incumbent upon them to get the necessary findings, in that case for a premises liability case. They'd instead submitted the case as a plain negligence. And this court said, no, you don't get a do-over. It was your duty to obtain the right findings the first time, and they failed to do it. This is just the flip side of that because it's an affirmative defense rather than a cause of action, but it was incumbent upon them to get the necessary findings. They failed to do that. The other authority is Rule 279 of the Rules of Procedures, which says on appeal, all independent grounds of recovery or of defense that are not conclusively established under the evidence and no element of which is submitted or requested are waived. So it was a choice they made. It could have been a trial strategy decision, who knows, but a choice they made of how to submit it. They submitted it this way. They failed to get the necessary findings on the individual factors, and therefore it's waived and the remand is not appropriate.
Mr. Dubose, is this a Rule 279 issue though? Because it seems like all of the elements or the factors were submitted here.
Well, it doesn't go to the part of Rule 279 that talks about omitted issues, which was the trial court's mistake. The trial court said it was their burden to get findings. He said they failed to get those findings, but then he takes a wrong turn and says, therefore, I'm entitled to make those findings in a matter of first instance, and proceeds to analyze the 6 factors. So that part of 279 doesn't apply, but there's another part of 279 that says if they don't, as I said, all independent grounds of recovery or defense that are not conclusively established under the evidence and no element of which is submitted or requested. Yes, I think that applies. So again, yes, Justice Guzman.
Mr. Dubose, I was going to ask about in Texas how these cases are typically submitted. Justice Busby asked Mr. Wright about that, whether they're submitted in granulated form, even though we're a broad form states. I didn't know if you had anything you could point us to about how these cases are typically submitted when there are disputed facts under the Ruiz factors.
Justice Guzman, I've looked and I can't find any cases that shed any light on that. It's interesting that throughout the trial, both sides' trial lawyers argued to the court that Louisiana law applied rather than federal law. And in post-trial briefing, we found Louisiana cases that did submit this as a broad form question with the Ruiz factors submitted as an instruction. But again, that's Louisiana law, and I'm not aware of any Texas case that have addressed that. I'm also not aware of how federal courts do it, because almost none of these cases end up in the Fifth Circuit after a jury trial. They're almost all summary judgment or directed verdicts based on the evidence in those cases. But in this,
Mr. DuBose,
yes, Justice.
on that issue, in the Brown case, there was a disputed fact issue about control, but it looked like it was a fact issue about who was giving the instruction at the time of the jury. And I think W&T's argument is our dispute is not over the facts. The facts are largely, if entirely, undisputed, but it's the way to be given the particular facts in answering the legal question. What's your response to that? And that the facts really aren't disputed. It's just how much weight to give control versus other factors, other Ruiz factors.
So first of all, Justice Blaine, I think that there are disputes about the facts about control. And I want to talk about control both in the broad sense and in the specific sense at the time of the injury. In the broad sense, and even though the question that was submitted to the jury starts out at the time of the injury in question was Wesley Fredieu, the borrowed employee of W&T, the first factor on control is worded this way: who had the right of control over Mr. Fredieu and the work he was performing. So if it's right of control that we're talking about, that is sort of the global question as opposed to at that exact moment. In terms of the right of control, we have something in this case that I haven't seen in any of these cases that talk about control. And that is some rather extraordinary testimony from W&T's corporate rep. He was the vice president of production operations. And at the time of the injury, he was the production manager responsible for several wells, including this one. And he said two very significant things. Not only did he say that Mr. Fredieu was in control of himself, but he specifically said in one instance that the W&T people did not have to control his work, did they? And when he says 3 times that Mr. Fredieu controlled his own work, the follow-up question was, and not Craig Black or Jim Mason, who were his foreman and his supervisor. And he said, that's true. So he not only said Mr. Fredieu was controlling himself, he said that W&T was not controlling him. Now, W&T points to some other evidence that may be true, but that's at least a fact issue. You can't look at his statement as corporate rep and say there is no evidence that they failed to control.
Do you, Mr. DuBose, would you look at control separately? In other words, whether at the time of the event there was less of a hands-off attitude, or do you generally how they directed his work throughout his employment? What do you look at to examine that control factor?
Yes, Justice Guzman, the question as it was submitted to this jury, the question was about the right of control rather than the actual control at that time. So if you look at right of control, I think the testimony of Mr. Guatro, their corporate rep, certainly raises an issue about that. But let's also talk about at the moment of injury, because that's also significant, because he was on another drilling rig. He was there with 3 other employees of QWC, who I think was a welding company, to fix a railing. And while he was there, he went walking around and found this problem with the Big Joe regulator. At that point, he got on the radio and contacted W&T. He says the reason he did that, it was because it was their property and he wanted them to know that they had a problem with their regulator and whether they wanted him to try to fix it there or to bring it back. They have a conversation on the radio. And in addition to that, I mean, this was something he'd never done before. It was something out of the ordinary. And when something like that, our safety expert says, industry standard is that you have to do what's called a job safety analysis, a JSA. And he says the standard of care is that you do a JSA in person, you do it orally, you also do it in writing, and it must be signed by all the people who are there. Now, our safety expert was critical of several things. First of all, he said they should have gone over to that other rig. It was a 10-minute boat ride, and they should have gone there and done the JSA in person, looking at the regulator to see if there were any problems. And they didn't do that. And in fact, Mr. Mason at trial testified that he should have, and there was no excuse for him not going there. So if they were controlling him, they would have gone over there and told him what to do, but they didn't do that. They had this conversation.
Were they giving instructions over the radio, albeit ineffective or faulty instructions?
They gave some instructions, and there's a dispute about what exactly was said. The reason you do a written JSA is so that we know, so that there's not a dispute. I mean, it's just like the same reason we rely on the clerk's, the reporter's record at trial rather than the lawyer's memories. And the written JSA, which is in the record, it's Exhibit 1, Plaintiff's Exhibit 1, it's very brief. The entire JSA for instructions on what to do, say block the valves on each side of the Big Joe regulator, remove, period, plug line where Big Joe regulator was removed. Now, the most important part of that is the middle part about the removal. That's where the problem happened that resulted in his injury. And the sum total of their direction is the word remove. That's all they said. Now, if they were controlling him, you would think they would
instructed him to remove it, right? They instructed him to remove it. And maybe they did it negligently, but they did instruct him to do that.
Well, the question that was asked is, who has control over the employee and the work he is performing beyond the mere suggestion of details or cooperation? I'm saying that if all you tell him to do is just remove it, that's a mere suggestion of details. That's not giving him instruction that qualifies as control under the Ruiz standard. The Ruiz case itself talks about control, and it says, in considering whether the power exists to control and direct a servant, a careful distinction must be made between authoritative direction and control and the mere suggestion as to details or the necessary cooperation where the work is finished as part of a larger undertaking. Cooperation, as distinguished from subordination, is not enough to create an employment relationship. And the state of the record on this point suggests that it was a cooperative effort. He was there to help them, often worked on his own, often without their direction or control. They were working in cooperative fashion rather than a subordination type of relationship. And that's what Ruiz says. And if you look at that law transposed onto the evidence in this case, there's at least a fact issue on control, both in the general right of control and control at the moment of the injury.
Mr. DeBose,
Factor, I'm sorry, Judge Boyd.
if I may, I'm sure, you know, when we judge moot courts, it's always a fun trap question to ask, what's the standard of review here? But here that seems to be a very relevant question to me, because ultimately everybody agrees the ultimate issue here on borrowed employee is a question of law. And if that's true, it seems to me the standard of review would be de novo. So would it not be appropriate for us to simply review the entire record and decide de novo whether he was a borrowed employee or not as a matter of law? And if that's true, even if we find that there is a fact issue as to one or more factors, can we presume that the jury would have found that factor in your client's favor and yet nevertheless conclude as a matter of law that he was not a borrowed employee?
Well, if you did that, Justice Boyd, you would be the first court I'm aware of that's approached it that way. Has said if there are at least two factors are disputed, then that disputed question has to be resolved before a court, whether the trial court or the appellate court, gets to make that determination as a matter of law. And now, most of those federal cases I'm talking about were remanded because there had never been a fact finding. They went up on either directed verdict or a summary judgment motion. But here, they had their day in court. They put on their evidence. They had a chance at a fact finding. They chose to submit it globally. And as Mr. Wright said, we have to assume they found all 9 factors in our favor. So at that point, the standard of review for reversing that jury finding is legal sufficiency. Is there legally sufficient evidence to support the jury findings? And I'm saying there certainly is under this record. Now, another factor I want to talk about is factor 3, which is, was there an agreement or understanding or meeting of the minds between the original and the borrowing employer? And there was a master service contract. Mr. Wright talked about Article 5, which is about indemnity. But more important is Article 3, which says it is expressly understood and agreed that the Wood Group is an independent contractor and that neither the Wood Group nor its employees are servants, agents, or employees of W&T. So the question is, was there an understanding? The contract says it is understood that they will not be employees of W&T. Now, the W&T cites federal cases saying that sometimes workplace realities can impliedly waive express contract provisions. I have several concerns about that. First of all, this same master service contract in paragraph 13, which is at page 56 of the supplemental clerk's record, says no benefit or right of control no benefit or right under this contract shall be deemed to be waived unless the waiver is reduced to writing, expressly refers to this contract, and is signed by both parties. So while the case is talking about in some cases you may have an implied waiver based on the facts, this contract says you can't waive unless you do it specifically, the parties agree, and both parties sign it. That's consistent with a long line of cases from this court protecting the sanctity of contract language, most recently in Energy Transfer Partners versus Enterprise in January of this year, when the court again mentioned the sanctity of contract language and said we have to say that almost every term. But in addition, the Enterprise case says that if somebody's going to argue waiver by conduct, they're required to either obtain a jury finding on waiver or to prove it conclusively. So what conduct is there here that conclusively proves waiver, that the parties knowingly agreed to change this operation? W&T points to the fact that he was under their direction and control. We've already talked about that's disputed. There's a fact issue on that. They say that he slept with them and ate with them. And that whole time he was wearing a W&T uniform. He was receiving W&T benefit in his paycheck, as well as benefits, and no, he never was treated by anybody as an employee of W&T. So while the courts say that contract language can be waived by conduct, what's the conduct here that waived it? Certainly in light of the contract provision that says that it has to be done in writing. So I think that the language of the Court of Appeals was put this best. It says the contract's characterization of Fredieu's status is not dispositive, but neither is it no evidence. So I think factors 1 and 3, there's certainly at least a fact question. Factor 5 is whether the employer terminated its relationship with the employee. Well, the evidence was that they did not terminate the relationship. They continued to be in communication with him. They continued to do training while he was working shifts on and off on the W&T rig. They met him at the dock every time his 2-week shift was over. W&T relies on case law saying that, well, if there's direction and control on the site, that may indicate the relationship was terminated. But Brown versus Union Oil, which is cited by both parties throughout this case, says that if the lending employer has the right to take the employee off the platform if they needed him elsewhere, then they have not terminated his relationship for purposes of this factor. There was testimony from both the supervisor, Mr. Monceau, and Mr. Fredieu, that, I'm sorry, that the group had the right at any time to pull him off that rig and assign him to another rig. So under Brown, that's enough to at least raise a fact issue in this question. So that's 3 issues there was a fact issue on. The other one we think there was a fact issue on is, I mean, they were all fact issues, but the next one that you should consider is factor 9, which, as originally stated in the Ruiz case, in many cases, I'm sorry, Justice Boyd, you have a question? Okay. In Ruiz case, in many cases say since then, the question is who had the obligation to pay the employee? There's uncontroverted evidence that the Wood Group and only the Wood Group had the obligation to pay him. The question that was submitted in this case over our objection was who had the obligation to furnish the funds from which Mr. Fredieu was paid. But even if you consider this factor under that language about who furnished the funds from which he was paid, there was no evidence in this case tracing funds that showed that Mr. Fredieu was paid by funds that came from W&T. They were invoiced for his work, and the invoices are at Plaintiff's Exhibit 8. There's a cover page on the invoice that shows a total figure for a number of employees, and presumably W&T paid that figure. And then there's breakdown behind that. But if this worked like it would in most situations, he does his work, he fills out timesheets, he's paid at the end of the pay period. And then at that same point, they send W&T an invoice, and later that invoice is paid. I mean, I'm guessing about that, but the point is, it's their burden of proof. And they never traced a connection between the money that W&T paid to Wood Group and Wood's Group's payment of Mr. Fredieu. So again, there's at least a fact issue.
Your time has expired. Are there any other questions? Thank you. Mr. Wright, we'll hear rebuttal.
May it please the court. I'm assuming my video's up. So the first thing I'd like to address is what do they concede? I've heard some equivocation by my friend on the other side. Page 35 of the respondent's brief, they say that their client conceded factors 2, 4, 7 and part of factor 6. And on page 36, they say, as shown below, although their client does not challenge the Court of Appeals holding on factor 8, that holding was that factor about who could terminate the services on the platform, which is what the question asked, went in our favor. So that's why I say only the issues that I've highlighted on my handout are the ones that we need to talk about. It seems like to me now it's Mr. DuBose who's complaining about the broad form of the question. And I would echo what Justice Boyd asked about, can't we just spot Mr. Fredieu all of those individual issues? And I think, yes, we can. And then you're faced with looking at the evidence on the ones that are really in dispute. Mr. DuBose talks a lot about the job safety analysis. Well, my question is, who did the job safety analysis? It wasn't Wood Group, it was W&T. Yes, maybe it was done poorly. Yes, maybe W&T should have sent somebody over there, all sorts of things. But when Mr. Fredieu went to work on this regulator, which as Mr. DuBose conceded, he had never worked on a piece of equipment like that before. He also said he called Mr. Mason and did what Mason told him to do. That's in 3 Reporters Record 105 to 107. He discussed with Mason step by step how to remove the regulator and was doing what he was told. 3 Reporters Record 171 to 2. So the fact that some steps weren't in the JSA, Mr. Fredieu himself concedes that he went over step by step with Mr. Mason how to do the work that was involved at the time he was injured. I don't think that raises a fact issue. There's been some discussion, some by name and some not by name, of this Brown versus Standard Oil case, or maybe Union Oil, out of the 5th Circuit. That case was tried, but the district judge directed a verdict. And the 5th Circuit said, no, you need to get these findings first. We've got the findings. We did not fail to ask for a finding. All the findings went against us. And now we're back arguing what we argued to the judge before he even submitted the charge. You ought to give a directed verdict on this because there isn't any evidence of it. And by the way, it's a legal issue anyway. So in answer to one of the other questions, yes, I think this court can easily look at the record evidence. I mean, the key evidence has been cited in the briefs. It's not that long of a trial anyway, but you can see what the evidence is on each one of these points. This idea that, we'll talk about the contract for a minute, that it can only be waived in writing by the two parties. Mr. Fredieu is not a party to the services agreement. So I don't believe he can rely on what those provisions say anyway. But if you look at the bottom of the page where the contract starts to say that the employees are independent contractors, that's on page 8 of the PDF, page 48, stamped at the bottom. This is out of the clerk's record. The very next sentence says, however, notwithstanding the foregoing, and it goes on to the next page with a lengthy explanation about this does not prevent people from being a borrowed employee. And here it references Louisiana workers' compensation law. It doesn't reference the Longshoremen's Act. But the point is, this contract cannot be read as excluding the idea that someone could be a borrowed employee. And combine that, and of course you have to read the whole contract. And we've already talked about the workers' compensation insurance requirements that require an endorsement that will cover borrowed employees.
If we, Mr. Wright, if we can take your concession that control was found against you, and that's been described as the central issue in determining whether or not someone is a borrowed employee, why, in answering the question of law, given that the other factors have both pluses and minuses, why wouldn't that resolve the question of law?
Well, first you'd have to see if we have established factor number one conclusively in our favor. And I say we have. So, you know, it's a mix.
So you do not agree that testimony from the vice president about control or lack of control by W&T on the platform for Wood employees isn't some evidence of Wood retaining control over its employees?
It was absolutely not any evidence of Wood retaining control. The question was whether Mr. Fredieu could control himself. And the Mosley case from last year at page 360 of the federal appendix site, I think we provided the court, says that Mr. Mosley argues that that Fieldwood, which was a borrowing employee there, did not exercise control because he didn't need to be told how to perform his job. That's the same thing that our vice president is talking about. Nobody needs to tell Mr. Fredieu how to do some of the jobs, not the one in question here when he was injured, because he conceded he needed to be told about that. He'd never done it before. But the Mosley—
Did he also say that the two that from W&T that would potentially be supervising were not supervising Mr. Fredieu? The two W&T employees, Mr. Mason and someone else?
Our vice president said that morning when he was supervising the welders or painters or whatever they were doing with the railings, nobody needed to supervise Mr. Fredieu on that. Well, of course, they weren't even there, but you know, that's the wrong time and the wrong issue. And they love that quote because it says Mr. Fredieu can supervise himself. But the federal cases universally say that's the wrong question. You have to compare the two. And this idea about cooperation and so forth, that comes, and Mr. DuBose quoted a little bit about larger undertaking. Look at the Standard Oil case from the US Supreme Court. That larger undertaking is what I described a while ago, where you hire a whole company. Let's say they wanted a workover on this rig and they hired Fluor or somebody to come out there. Well, those employees of Fluor are not going to be borrowed employees of W&T because they're all coming out there to do a specialized work. That's not what we have going on here. There is no larger undertaking. It's just Mr. Fredieu being loaned out to W&T. I see my time is almost expired, and I would just say if the court has other questions.
Any other questions? Thank you, Mr. Wright. Case is
Thank you, Your
submitted, and the court will take a brief recess. Thank you.
Thank you
Mr.
very
Wright.
much.
Mhm.
Should we ask to be excused?
Gentlemen.